the Wayfarer Parties just filed a motion for judgment on the pleadings. It's a big deal. It's past midnight. It's way past my bedtime, but let's go through it. So, what is a motion for judgment on the pleadings? This is, you can think of it as almost exactly like a motion to dismiss. The standard applied on a motion for a judgment on the pleadings, an MJOP, is the same standard that you would apply in assessing a motion to dismiss. That means you look at the four corners of the complaint. You assess whether the claims can legally stand up. So can the plaintiff make those claims on legal grounds? Why do we have these two rules? Sometimes you want to wait for the pleadings to be completely settled, all of the amendment deadlines to have passed, to know exactly what the claims are going to be. And at that point, you might file a motion for judgment on the pleadings. That would be after the deadline by which you'd have to file a motion to dismiss. So a motion to dismiss has to be filed pretty soon after a complaint is filed. But a motion for judgment on the pleadings can happen pretty much any time before a motion for summary judgment. Someone might want to file a motion for judgment on the pleadings before a summary judgment because they want to narrow down the claims that legally have no basis to be before the court. They want to narrow those down and only get to the claims that have a potential factual dispute that discovery would reveal, and that would be ripe for a trial, or not even a factual dispute, but that evidence would be needed to dispute what is in a complaint. So a summary judgment motion would allow you to bring in evidence about things that you've discovered through discovery and evidence to prove your legal claims. The motion for judgment on the pleadings doesn't allow you to show any evidence. So you're simply saying, based off of what they have alleged, they cannot bring these claims legally. Another reason why a party might want to bring a MJOP is because they want to preserve the arguments for appeal. So bringing these legal arguments now about how the claims fail as a matter of law preserves their ability to raise those issues later on appeal. So if there is a adverse order on this, let's say this motion is denied, then this could be something that the Wayfarer parties could appeal. So think of it as a motion to dismiss. If it's granted, depending on which claims it's being granted for, those claims could go away completely. Like gone. They're gone. You can't bring them. So that's the purpose of bringing this, is to get rid of claims. So let's go through the arguments. First, they talk about extraterritoriality. That is a hard word to say at 12:20 a.m. So extraterritoriality is applying a state law outside of the territory in which it is supposed to apply to. So states have their own laws. There's a presumption that those laws are meant to only be applied to the people in that state. You can't just go, I'm going to sue someone and say like Arizona law applies to them. That would be chaos. So there are things written within the laws that will explain whether or not it can be applied extraterritorially. It's very complicated. We're not going to get into that here. But here they're saying that the California laws that Lively has brought claims under don't support extraterritoriality. So for that California law to apply, the complaint has to establish a substantial connection between the situs of the legally relevant conduct to California. Courts look at the core of the wrongful conduct. Everything here happened in New Jersey and New York. And that actor agreement that included a choice of law provision that said, California law applies, doesn't overcome the lack of territorial reach that particular law has. And case law talks about this in depth. In order to overcome the presumption that there's no extraterritorial application, Lively would have to show that the legislature intended to extend FEHA to New York residents or to conduct that happened outside of California. And there is a lot of case law that says that you can do that. Next, they talk about how plaintiffs' Title VII and California FEHA, Fair Employment and Housing Act, claims fail because she didn't exhaust her administrative remedies. Now, I want to show you this paper from March where I clocked this, that there was a failure to exhaust her administrative remedies and that they fail. On its face, they fail because they didn't do it in the right procedure. Under both California FEHA and Title VII federal law, you have to timely bring an administrative complaint, obtain a right to sue before you're permitted to file a lawsuit in state or federal court. That is a requirement under both laws. And that is not what happened here. So they're arguing that It Ends With Us movie. So remember, It Ends With Us movie had an LLC. They're saying that It Ends With Us movie LLC was not named in the CRD complaint. So because they were not named in the CRD complaint, Lively doesn't have the right, because she didn't obtain a right to sue, she doesn't have the right to file any claims against It Ends With Us movie LLC. So those claims should be dismissed because they failed to exhaust their administrative remedies against that particular defendant. Additionally, they say that they were out of time. So it was outside of the time limits. Now, I went into detail about this back in March. I don't think they hit this hard enough, because if it was me, if I was Wayfarer's counsel, I would have hit this really hard, because the requirement is that when you bring a federal hostile work environment claim, so under Title VII, you have to file a administrative complaint. So here it would have been a CRD complaint within 300 days of the last alleged act. So what was the last alleged act of workplace harassment? If you look at Lively's complaint, you could interpret the last alleged act of workplace harassment being June 4th. The most generous would have been that June 4th meeting, that New York apartment meeting that they had. And that is over 300 days from when she ultimately filed her CRD complaint, which was on December 20th, 2024. Lively herself alleges that on June 14th, she says to someone that you're safe on set. So she alleges nothing went wrong after June 14th, 2024. And that is still over 300 days from December 20th, 2024. So she is barred. And I've thought this from the beginning because I clocked it early, but she is barred from bringing that particular claim under Title VII. Now, maybe they're going to hit this on a summary judgment motion. I'm not sure why they didn't go hard on this, but I would have. Next, they hit the elements of retaliation that we've talked a lot about. So the first one is whether or not there was an adverse employment action. That is one of the elements that she will have to prove, that there was an adverse employment action. She's essentially alleging that there was negative publicity about her commencing in August of 2024. She doesn't allege that there was an adverse employment action while she was employed. You cannot assert that your adverse employment action happened after you've left the company. There's no case law or precedent supporting that. In fact, they note that she earned her PGA mark and everything she wanted, control the film. So there is no adverse employment action. Now, that extrinsic evidence is not going to be considered. If it were to be considered, it would convert it into a motion for summary judgment. And so it's probably not going to go down that path. But just based off of what she alleges, she doesn't allege anything bad happened to her while she was still employed. Next, they go into a detailed argument about Lively's failure to plead a retaliatory causal link. So a link between the protected activity and the alleged smear campaign that they're saying is the retaliatory act. So they over a year has passed since plaintiff's May 2023 complaints and the August 2024 alleged smear campaign. And there's loads of courts and cases that say 3 months is around the marker, between 3 and 6 months maybe, but a year, here 15 months, no way, no how. There's way too much time. There's way too much of a gap to overcome the presumption that this is too remote of a possibility, that the actions that you're alleging are connected to the alleged protected activity. They say even if you assume that January 4th was the last alleged protected activity, that's still 7 months until she alleges something negative happened to her in a retaliatory manner. And lastly, they use Lively's own complaint and own allegations about what was said between the Wayfarer parties around August 2024 to show that there was a lack of a retaliatory intent. They were prepping for bad PR and anticipation of what Lively was going to do, not in response to what she had done. I'm not going to go through the defamation stuff because this video has already gotten way too long, but I'll just give you my prediction here. They had previewed this for us, that they were going to file an MJOP, so we knew that it could be coming, didn't know when. And I think it was a smart move because it will narrow down the claims to some extent for summary judgment. It's not going to get rid of everything, but I think it will get rid of a lot of things. And this is a really easy way. This is essentially giving the judge an easy way to get rid of some of these claims. And judges love easy ways to get rid of things. Summary judgment is not an easy way because he has to weigh evidence. He has to make a determination about evidence. So this is an easy way for him to get rid of claims. And it's easy because it's based off of law. If you don't follow the procedure, if you don't have legal grounds to bring a claim, then you don't get to keep your claims. And that is a decision he's already made in this case against the Wayfarer parties. So I would not be surprised if he granted a lot of this against Lively. It's way too late for me to sit there and make specific predictions. I'll think about it more tomorrow when I'm more awake, but just wanted to make sure that you guys have this because I know you're hungry and you're reading for it. With that, good night.